I hope you are not very cold wherever you are. I am extremely cold in Queensland, but hopefully I am gonna warming up by the end of this session. My name is Agnes Kemenes, and I am the principal lawyer at No Borders Migration, and I just would like to have a quick conversation today about how the changes to the TSMIT will impact on your sponsorship and future strategy. Next slide, please. Okay. Just very briefly, who are we and what we do? Okay, we are a migration legal practice with further expanded into 4 different areas of the law, which is employment, property, and commercial, and of course, migration law. We started our practice in 1998 under the good old system of a migration agency. And later on, we have become a law practice because all my team and myself, we are practicing lawyers, and I am the principal lawyer as well. Why we do what we do? Probably you ask the question, what is this accent? Okay, just try to figure out. So this is a Hungarian accent, and I'm a migrant myself, came to this country 39 years ago. And I believe that we are here to make changes to people's life, and this is our why. And for our corporate clients to showing a way forward and make sure that they are successful in their business. Next slide. These are our 4 entities and divisions. So we are able to support our migrant clients with all these other divisions. For corporate clients, mostly our employment law services are very beneficial. Next slide, please. Okay, what would be our discussion about today? It would be, first of all, understanding the salary threshold, key changes to the key changes coming in 1st of July 2025, impact of employer-sponsored visas, and that can be permanent and temporary, what type of industries really affected, and strategic action what you can take, FNQ DAMA consideration, and all DAMA consideration, really, not just the Far North Queensland consideration, but every DAMA consideration is about the same. Legal checklist for sponsorship ready contracts. So that's what we're going to talk about today. Next slide, please. Understanding TSMIT and the related threshold. Okay. The TSMIT is, as you can see, it's the temporary skilled migration income threshold, which has been established a long time ago, probably after the Howard government that was introduced. And, initially was $53,000. And when the Labour government came into power about 3.5 years ago, if I'm correct, then it has been increased to $73,000, and now there is a change coming again, $76,000. I mean, all the changes were actually affected by the decision-making process of the union. They were extremely unhappy that companies are bringing in overseas candidates to fill positions, and they felt that employees who were brought in from overseas, they were underpaid, they were, not that properly worked overtimes, etc., and therefore they changed by about $20,000 the minimum threshold for the employer-sponsored candidates. Okay, now in a temporary regime we have 2 key subclasses, or 2 key separate divisions. One is the core skill, and the other one is the specialist skill income threshold, or the income threshold for the core skilled occupations as well. This is really the only difference between the two headings. I just call it headings because they all the same. They all the 482 visa regime, but the specialist skilled occupation list includes, highly skilled people or so-called highly skilled people. Sometimes the department, if they would like to have some changes, what occupation stays on the list or what not, then this is a instrument for them to tighten up or loosen up the process. Say, for example, the coffee and restaurant manager has been put on a specially skilled occupation list, which means that the salary level is much higher than the general salary under the core skilled occupation list. At the next slide, I will explain what are these differences. Can I have the next slide, please? Next slide. Excuse me, yes, thank you so much. Okay, sometimes we have a little technical issue, so forgive me for that. So as you can see, the current threshold is until 1st of July is for the core skilled list is $73,150 plus superannuation. This is relevant for the 482 and for the 186 visa stream, okay? This will be increased to $76,515 from 1st of July. Under the specialist skilled list, okay, as I mentioned before, this highly skilled occupation list, the current salary level is $135,000 plus GST. And from 1st of July, that will increase to $141,200. Now, just for interest, okay, say, for example, a management consultant would earn, $130,000 or $135,000 now under the current regime. And from 1st of July, it would be $141,210. Also, for example, for personal assistants, like if you're in a business of recruiting executive assistants, then an executive assistant salary would be also increased to $141,210 because the department has decided that an executive assistant or personal assistant is actually not a core skill occupation, but rather a specially skilled occupation. But sometimes may smaller companies, why they require a personal assistant for the MD or the CEO, they are not in a position to pay $141,000. Larger corporations certainly, and probably they may maybe pay more salary for a personal assistant. This is just a reflection on what the difference is between the core skilled list and the specialist list and what type of occupation may come under the specialist skilled list. This is relevant to the 482, okay? And also the TSMIT will be $76,515 for the 494 visa stream as well. The 494 visa stream is actually the same visa stream as the 482, but it is in a regional area. And if you're not familiar with this visa category, it is developed for the regional area where you can sponsor people initially with the idea of you may pay lesser salary and the occupation what is not available for the general skilled under the general skilled list. Then they introduced the regional occupation list, which was the ROL. And that's now with the new system, the core skilled list and specialist list is almost abolished, and you can sponsor people under the existing two list for the regional area as well. The only difference is this is for up to 5 years temporary visa, while the 482 temporary visa stream is available for up to 2 years or 4 years, depends on which occupation we're talking about. Okay. Now, usually this salary increase is indexed according to our CPI. Sometimes you don't see that, sometimes you see that every year. This is my experience since 1998, and this is up to the department. Okay, next slide. Impact on sponsorship and visa application. So as you can see, we list a couple of impacts. So new nomination must meet with this new threshold requirement. And here I would like to remind you, if you have advertised a position under the lower scale of salary, and that is going to be finished in July, then you can't use that salary level. So you may would like to reconsider to make changes to the salary level in your advertising to meet these threshold requirements. If you are able to offer a sponsorship and nomination before 1st of July, then the current threshold is relevant to $73,150. Existing application, as I said, or lodged before 1st of July will be assessed under this regime. If you lodge the application on the 29th or 30th of June, your application still will be assessed under the current regime, okay, even if the nomination will be approved in September. So there is no issue with that. Visa holders has the same, as if the because this is relevant to the nomination, not the visa application. But once the nomination is approved, the visa applicant visa will be granted for the occupation with the nominated salary level. So they will know exactly this is the salary what I have to be paid, okay? Compliance, employer must ensure that they offering the correct salary, and they making the correct salary payment throughout the life of the sponsored visa or the nomination period. Okay, next slide, please. Okay, this is just a short summary of what what industry categories can be affected with this change. Usually, certainly the hospitality and tourism industry salaries are not as high as in other industries. I mean, maybe a chef would earn, say $80,000, $90,000. I am not 100% sure if you have chefs in your industry, but certainly cooks and coffee managers are not earning that high salary, so that can have an effect. Coffee managers can be sponsored only in a regional area with normal salary, as I mentioned, because in a normal 482 visa stream, the coffee and restaurant manager would be entitled to the specialist skill salary level, which would be $141,000. Construction and trade, that can be affected, but I believe recently the construction industry and related trade occupations are pretty much above $76,000. This is what I see from my clients' instructions, and usually 86, 78, 92. So I don't believe that there will be a huge effect, okay? Certainly will be a huge effect on aged care and support services, as they usually offer a lower salary. But for aged care and support services, there is a labor agreement which is available where you can negotiate a salary level 10% below the relevant target. Yes. Um, and the issue is with the labor agreement that the concession available is only 10%. Okay. So if the salary level is 76, so if you deduct 7,600, it would be about $68,500, which is really much closer to the salary level what is paid in aged care and support services. So as I said, labor agreement is available, or in a regional area where DAMO is operating, it's available. So South Australia has a DAMO facility, and also Queensland, but the Northern Territory and WA, but really New South Wales and Victoria is just out in a very, very regional area where the DAMA is operating. Agricultural and retail sector, again, that can be affected because the salary level is pretty low, especially in agriculture, according to my understanding, and the companies who we are working with. And usually managers are earning above the TSMIT, and people who are working out on a field or in packaging or other areas, they won't earn this salary level. Therefore, it is a little bit challenging to sponsor those people. Regional employers, again, can offer less salary under the DAMA regime, because under the DAMA regime, the 10% concession is available for employees. Next slide, please. So FNQ DAMA specific consideration, okay? So as you can see, the occupation, the FNQ DAMA has a special occupation list. Townsville in Queensland has a special occupation list. South Australia has a special occupation list, okay? This agreement, because this is a labor agreement with local government, not with the Department of Home Affairs, those facilities, those bodies would offer special occupation lists. So, for example, Far North Queensland occupation list includes many, many occupations that is not available for sponsorship. But, for example, restaurant supervisor or housekeeper. So certain occupation that wouldn't be not available otherwise, this DAMA sponsorship and labor agreement is offering those sponsorship opportunities and offering concessions, okay? Some occupation has to be between level 3 and level 5. Just a reminder here, under any labor agreement, the skill level has to be minimum level 4, okay? So under the usual labor agreement which you're negotiating with the government, skill level for an occupation has to be minimum 4 or maximum 4, depends what we look at, okay? And the concession under the DAMA would allow up to level 5, all right? And you can negotiate the salary, as I mentioned, you can seek a 10% concession. If the DAMA endorsement come through before 1st of July, then your salary level stays as agreed to. If the endorsement has not been finished before 1st of July, but lodged before 1st of July, that is also fine. And if the DAMA application lodged after 1st of July, you have to get the new salary level, and you have to negotiate the price according to the new TSMIT and seeking the 10% discount. Can I have the next slide, please? How can you prepare for the changes to the threshold? You can have a look at your employment offers, and also your labor market testing. I mean, when you require a labor market testing, you would require to meet the minimum TSMIT, okay? And if you already advertised for one of your employee to be sponsored, or you already advertised under a nomination scheme, then you have to look at when is that labor market testing is coming to an end. Any advertising for a labor market testing has to be done for 28 days. So if you started 1st of June, your labor market testing will be finished on the 28th of June. I mean, not labor market testing, but the advertising has to be run until 28th of June. So the salary level would be perfectly fine, okay? But you must lodge the nomination as well before 30th of June, okay? So you cannot lodge a visa application with that advertising in July, because then is a change to the salary level. Usually, and this is a concept of what you can use and what we use for our clients, we use a scale of the, a certain scale of the salary level. So we might start, maybe we say the salary is between $72,000 to $83,000. With that, you meet the previous salary level and you meet the new salary level, okay? So that's always beneficial. And sometimes also, if you have an existing employee who may pay lesser salary than your prospective employee would be paid, then you also advise that use maybe a lower salary as a starting point and use the higher salary as a scale. And with that, you cannot be in trouble. Oh, why are you offering this person a higher salary when I'm working with you for much longer? So usually this has two edge, okay, like as a sword, two edge, and that's protecting you for the labor market testing, and also is giving you an opportunity to protect your interest regarding your current employees. Strategically assess applicants near the especially skill stream threshold, okay, because that's going to have a serious salary increase. $10,000 is a pretty, or 11,000, what is that? No, sorry, $6,200 is a reasonable increase to that salary level. Say we had a client who was a chiropractor, and since December, the salary level has changed because they removed chiropractor from a general core skilled occupation list to a specially skilled occupation list, and the chiropractor would needed to be paid $135,000. And in this instance, the employee was eligible for this salary because he was working quite sometimes as a registered and certified chiropractor, and the base salary for a chiropractor is anywhere around $125,000. So a lot of components here, okay? And here I may just take a minute to explain the difference between the TSMIT and the market salary, okay? Now, I don't have that here up on the slide, but I think you all familiar with the market rate and what you need to offer. So if the base salary under the TSMIT is going to be $76,000, but the market rate for that nominated occupation, what you're offering, going to be $85,000, you cannot offer $76,000 for the nominated candidate. You always have to offer market rate. And market rate is also important if the market rate is relevant to the location where you are nominating the person. What I mean by that is, if you are in Adelaide and you would like to employ someone in Adelaide, then you have to look at the market rate in South Australia. You cannot look at the market rate in Sydney or in Queensland, because I have seen nomination refusers where the case officer said, oh, your nominated occupation is in Queensland, but the market salary report um, includes salaries from New South Wales. So, I mean, sometimes even if you use New South Wales is a higher salary, and if you're offering higher salary, that's maybe okay. But just remember, always use the relevant location, because with that you cannot go wrong. And how to calculate market rate is you have to select a couple of advertised salaries, and say if you select 3 salaries and you add them up and you divide it back by 3, then that's going to give you the market rate. And you have to offer that salary or above that salary. And if that is above the TSMIT, that is perfectly fine. Okay. One thing what you cannot do, offer an occupation under the TSMIT. Okay, doesn't matter, the market rate is maybe $70,000. So say, for example, if you're employing a hairdresser, hypothetically, the hairdresser may earn $72,000. You won't be able to offer a position at $72,000 to a hairdresser, even if the market rate is $72,000, because this is below the TSMIT. So in this instance, how you can overcome to change to the TSMIT level, at least, that you can say that person will be a team leader of the hairdressers, okay, so you have to pay higher salary, or the person is a senior hairdresser with 10 years work experience. So there are opportunities to bring up the salary to the TSMIT and not the market rate, okay? So you have to be very careful with that. So just repeat again, we have TSMIT and we have market rate. And within that, you cannot pay the salary under the TSMIT, but if there is a market rate, you have to pay the market rate. How you sometimes can overcome not to pay the market rate is when you're employing another person in an occupation, okay, same task, same attributes of the employee, okay? So that employee is also 2 years experience, the currently employed 2 years experience, same occupation, then you can pay the same salary as you pay for your already existing employee. And with that, what you can do as well, you just have to show the pay slip of the other employee, and that would end the employment contract, and that would satisfy the department. But in that instance as well, you must pay the salary above the TSMIT, okay? I hope that's something which, enlighten you a little bit, because this is always very tricky with the department. Next slide, please. Okay, I'm so sorry, it's a little bit together. Labor market testing. So that's what I have done already, okay, and plan for renewals and associated salary increases. So very important, when you employ someone and you employ someone for 3 years, you do not require to pay the person a increased salary. So even if the TSMIT is increasing this year, and you employed someone last year with $73,200, you don't require to increase the salary because the salary increased now, because you have been approved at that salary level, okay? So if someone in the future come up to you and says, hey, I'm working for you for 2 years, can you support me for a permanent residency? Then the salary level has to be according to the TSMIT, and at that time you may have to increase their salary to that level, what is the TSMIT level at the time when they changing to the new visa. But during the period of the temporary visa time, you do not require to change the salary level. As I mentioned at the beginning, the TSMIT is relevant to the 482 and the 186 visa stream, and the 186 is the permanent residency. Okay. Evaluate your current workforce and determine which visa holders may require renewals beyond 1st of July. I mean, we have a number of clients where we're rushing now to lodge the application before 1st of July because they're transiting to a permanent residency and the employer is happy to offer them a permanent residency. Or we have people where, they want to extend their 482 and we have to lodge the application before 1st of July just to be in line. Or if they're paying higher salary than the new TSMIT will be, we're not really worrying about that. Okay. Next slide, please. So early lodgement, budget for annual indexation, employment contract updates. I mean, this is something which is very important, the budget for annual indexation, and probably, as I mentioned before, if your candidate or became as an employee, if an employee is eligible for permanent residency after 2 years, then you have to think about, in 2 years' time, you have to pay a higher salary. Okay, that's you may not increase every year. I mean, if an employee is great, why you would not increase and reward them? Okay, and you want them to stay with you for a long period of time. I know salary is not always the key motivating factor for employees, 100% agree with that, but that can be, something which a overseas candidate can appreciate. But you need to be prepared that if they're going into permanent residency, you will require to pay the salary level at the time of the permanent residency application salary level. Okay, so that's just a little bit thinking ahead. Also have a look at your employment contracts, okay? And employment contracts is very, very important to protect yourself. And also the Department of Home Affairs, when you're sponsoring someone or nominating someone for permanent residency, would like to see the contract for 2-year period with a view of extending it beyond the 2-year period. So that has to be included in the employment contract. That is, under industrial law, you are only required to, meet the requirements of the Fair Work regulation. But immigration has this idea, okay, this permanent residency contract is not just for 2 years, but it can be beyond that. So it can be included in that. Also, when you're employing someone say, for example, in an occupation that is a sales role, or somewhere where they would be receiving commission, then have the base salary, okay, included in a contract, but any commission, what they are entitled to, should be in a separate addendum, because the commission can be varied and you don't really want to lock yourself into the employment contract to say, hey, this is going to be your commission, and that won't be, changed because that's in an employment contract. Next slide, please. Question and answer. Oh, this was my shortest presentation, but really this was mainly just the salary increase and how is that affecting you. Yes, question and answer, please. Mao, can you please moderate?
Yes, anyone who wants to ask questions, you can unmute yourself or you can type in the chat box. Thank you.
Just a reminder that everyone will receive the little summary of the presentation. And if you have any question, we are here to, answer your question maybe after this meeting. And, you can contact me or the office, and we're very happy to guide you whatever guidance you require. Okay. Mao, no questions?
Yeah, no questions at the moment. You can scan the QR code if you want to book 30-minute consultation. Um, there's one question,
Yeah.
please. What about the Visa 186 if you have 482?
Yes, the 186 visa is available for a employee after 2 years working full-time with the company. And at the time of the nomination for the 186, you must offer the same salary level as it will be um, in legislation or in power at the time of the 186 nomination. So if someone is nominated, say, June this year, and the visa is valid for 2 years or 4 years, then after 2 years, this person will be eligible. So in 2027 June, you would be able to sponsor this person for permanent residency, but you have to check what will be the TSMIT at that time, and you have to nominate. That's a nomination only, no sponsorship. You need to nominate that person with that relevant salary level. That is something very important. And please, it's another very important, little in-house information that permanent residency for an employee is available after 2 years, but not exactly after 2 years. Is 2 years minus 1 week. Okay, so if you're nominating someone for 2 years only, that employee and you as an organization must make sure that that person takes up the position immediately after the grant of the visa, because they will have 1 week to play with at the end of the 2 year period to lodge a permanent residency. So why is this important? Because if the person takes maybe an unpaid leave because there are some family issues back in their home country, or they got sick and they require longer medical treatment and they take, unpaid leave, they would not meet the 2 year requirement for the permanent residency. So for that purpose, we usually recommend our clients to apply for a visa for up to 3 years, not just up to 2 years, because then you do not require to renew a 482 visa. The 482 visa will run for up to 3 years. The only difference is that you have to pay an extra $1,200 or $1,800 SEF levy at the initial time of the application. So it is just keep it in mind, okay? 2 years, yes, but minus 1 week. If the employee meets that requirement, perfect. If the employee would not meet that requirement, there would be a requirement to renew the visa, the 482 visa, okay, and renew the nomination as well. So you would need to advertise the position as well, and wouldn't be eligible for the 186. If, on the other hand, the initial temporary visa was sought to be granted for 3 years, then the person wouldn't have a problem and you don't need to pay any additional application fee. It's just running. So maybe the person will be eligible 2 years and 3 months for the permanent residency, so can change to that. Have I answered the question?
Yes.
Excellent. Thank you so much. Thank
Well,
you. Anyone has any other question?
Agnes, I think there's no more questions, so we can end the session.
Thank you so much, Mao. Thank you, everybody, for attending. I hope you learned something today, because that's the aim of this presentation. And I wish you all the very best for the long weekend, and see and talk soon. Have a lovely day. Bye.